I'm Michael Waddington with the Military Law News Network, and today I'm joined by attorney Ernesto Gapasin. How you doing today, Ernesto?
Hey, things are great, Mike. Everything's going well. Just handling a lot of trials right now and really taking it to the government.
All right, well, listen, as we've been discussing on this network and also amongst attorneys, no matter what the military does, no matter what the Air Force, the Army, the Navy, the Marine Corps does, the leadership to show that they're taking a tough stance on sexual assault, Congress is relentless with claiming they're not doing enough, they want more done. And that's going to be the topic of today's shows. There have been some really drastic measures underway as a result of the Naval Academy Article 32 that just happened recently that involved sexual assault. Ernesto, do you want to fill our listeners in on the background of that case and what's happening?
Sure, this is an extremely high-profile case, Mike, and as you know and as I know, we've been following this case. This involves some of those Naval Academy football players who have been accused of sexually assaulting a female, and it's our understanding that based on some of the media reports that the defense attorneys, and these are the allegations made against the defense attorneys, that they were attacking her too hard, they were attacking her credibility, and that this went on for hours and hours. And the media really went out on a limb to say that this particular alleged victim was not being treated well or treated fairly at this hearing. And what's happened is that this kind of created this spark, okay, this spark within the ranks of politics to change how Article 32 hearings are conducted, and maybe not even to change them, Mike, but to get rid of them entirely. And I got to tell you, Mike, you know, I'm shocked by these reports, and I really shouldn't be shocked, right, Mike? I really shouldn't be shocked. I shouldn't be surprised based on the constant trend towards doing everything possible for the government to prosecute and to win these cases, even with little evidence.
You know, Ernesto, I'm shocked as well. What started out as a story of the defense lawyers allegedly harassing an alleged victim has now turned into another attack on the military justice system. And I was recently at a court martial at Altus Air Force Base that involved a sexual assault just last week, and I met with what my opponent was a special victim prosecutor, a very seasoned, very well-respected prosecutor in the United States Air Force. And when I was speaking to him during one of the recesses, he had told me that in Congress right now, there's a big movement underway, and he thinks it's going to pass where they're going to either get rid of the Article 32 altogether, particularly in sex assault cases, or at a minimum, limit the Article 32 and not allow the accused and or his attorneys to even be present, which that would deal a tremendous blow to the rights of service members accused of not only sexual assaults but any crimes.
Mike, let me respond to that, because these Article 32 hearings, they're mandated under Rule of Court Martial 405. These Article 32 hearings are so important to the defense, and here's why. The prosecution, they have the opportunity to investigate a case for months and months before they ever prefer charges. Sometimes even over a year. The prosecution has an opportunity to investigate, to interview witnesses, to look at the evidence, to review the crime scenes. But what opportunity does the defense have once the preferral of charges happens? Because think about it. These Article 32 hearings can take place almost immediately after preferral, right? So now, Mike, here you have the government who's had months and months to prepare. Well, guess what? These Article 32 hearings, this is the first crack at the case that accused has. The evidence could be so terrible. There could be very little evidence against him. But again, when we're dealing with sex assault cases, there's so much about it that's political. These cases get prosecuted. So now we have the Article 32 hearing, which gives that accused, Mike, an opportunity to cross-examine witnesses, to examine all the evidence against him. It gives him an opportunity to elicit testimony that can be used later for impeachment at a trial. it's also an opportunity for the defense counsels to elicit testimony for preparing motions closer to trial if the case gets referred. And Mike, to do away with an Article 32 hearing would be a such a blow to an accused full and fair hearing as mandated to him under the Constitution. And I'm not trying to get idealistic with you. Practically speaking, that Article 32 hearing, that is the first crack at a case that an accused has.
Well, Tim, think about from another perspective. The reason that the Article 32 is also important to the prosecution and to the government is because let's say someone does make a false allegation. Let's say a witness's story doesn't add up. The witness is a liar. They can't remember anything. Well, the government never really gets a chance to hear that witness testifying under cross-examination until the Article 32. So sometimes, it still happens, sometimes when you go to the Article 32, the investigating officer, the prosecutor, and everybody in the room realizes this person is not a victim, this person is not truthful, this person is not even credible. We're not going to spend several $100,000, which is what it costs nowadays to try one of these big cases from the government's standpoint, because they have to pay for experts. They have to take the jury out of their day-to-day duties and put them and sit them in a jury box for a week. They have to go through the whole appellate process. You're talking flying in witnesses from all over the world, and the case can take sometimes up to a week. So these cases are very expensive. I mean, just because someone's in the military doesn't mean that the time is worth nothing. You know, you have 7 or 8 colonels and a couple of sergeant majors on a panel. Add up the amount of time and money that it's costing the government to even have them sitting there. So it can be sometimes not worth it to go forward. So bottom line is the Article 32 gives the government the opportunity to see what type of case they have and to do the right thing. If the charges are not warranted, then sometimes at Article 32 is the government sees that and they say, okay, you know what, we're going to give this person, let's say they're accused of sexual assault and adultery. The adultery is proven, the sexual assault's not. And they could then turn around and give that person NJP or an Article 15 and move on. But what's going to happen now is everything's going to go to, if there's no Article 32, everything's going to go forward. It's going to go to a court-martial. And I think it's also going to really hurt the government as well because they're going to get ambushed a lot of times and they're going to be crushed by experienced defense attorneys when the first time their witness ever takes the stand is at the actual trial in front of the panel. So it cuts both ways here, and either way, it hurts the military justice system if they go ahead and get rid of Article 32s.
Mike, those are absolutely great points, and that's something that we can easily forget, that prosecutors sometimes, they may have so many cases, they don't have the chance to interview some of these witnesses. And then we get to the 32, and then they get to observe how their alleged victim deals with cross-examination. And when they see that, you are absolutely right. Hey, you know what? We've got after a 32, a prosecutor may say, we've got a case with bad facts, bad evidence, and a bad alleged victim. Why spend $50, $70, $100,000 to prosecute this case when we're going to lose? And that's an absolutely great point. And what comes to mind when I think of Article 32 hearings is that it's not a waste at all. It's not a waste in manpower or resources, but in fact, an Article 32 can actually bring about greater judicial economy and help the workflow or the flow of all these cases and courts-martial going on throughout the military branches. But that's a great point, Mike.
And Tim, you know, I'm sorry, Ernesto.
Okay.
Ernesto, another thing is the government at the Article 32 has the ability to even perfect their case. Let's say the case is a okay case, okay, but maybe they got the charges a little bit wrong. Maybe they didn't charge the defendant with the right crime. Now they're not going to have that ability after the Article 32 to say, you know what, we actually charge this person with aggravated sexual assault. In reality, it should be wrongful sexual contact because, you know, if we go forward on this charge, we're probably not going to win. So they can then amend the charge sheet. That's a big thing that happens at the Article 32 is they amend the charge sheet, they perfect their case as well. It's just not all the benefits don't really go to the defendant. And I would say that the benefits of the Article 32, the benefits of it, help the prosecution a lot more than it helps the defense. Here's another problem. If a witness testifies as it is right now at an Article 32, and then something happens to that witness, if that witness was subject to cross-examination and under oath, and they recorded the testimony, guess what? Let's say the witness refuses to cooperate, or the witness, God forbid, the witness dies. The government could then use that Article 32 testimony if the defendant was there to cross-examine them, the defendant's attorney, at the actual court-martial. So what happens whenever there is no Article 32? Then they don't have the ability to use that testimony. And I've had cases where we waive the Article 32, which I don't advise, unless you have a really good reason. We did it so that we couldn't lock in witnesses in theater, okay, over in Iraq. So what would happen is we then went straight to a court-martial. Some of those witnesses had problems showing up at the court-martial, and guess what? It was to our advantage. Whereas if we would have done the Article 32 and they would have recorded all that, then the outcome might have been a little bit different. So I think that that the victim rights advocates think that they're helping victims and helping the military justice system, but frankly, in terms of justice, it's the wrong approach. And I think that it actually, depending on how we come at it, could actually help defense attorneys gain more acquittals in the long run.
And Mike, let me just address something regarding victim advocates. You know this. You're an experienced attorney. I'm an experienced attorney. We only do military cases, and we know that victim advocates don't understand how the system works and how the system works better. Okay? So too many times victim advocates act and move forward based on emotion. So they hear about this Naval Academy case and what happened at the Article 32 hearing. They hear rumors or statements or comments that this alleged victim was just beat up, was just harassed. So what happens? It becomes something emotional to the victim advocates. So they contact the commanding generals at whatever base or post they're at and say, this is a problem that has to be dealt with. And then the lobby groups come in. I mean, Mike, this is the victim advocates, for them to hear what happened at the Article 32 hearing involving the Naval Academy case. They are moved by emotion. They don't see it the way you and I see it when it comes to judicial economy and the rights of the accused. But moving on from that issue, I want to address one other matter with regards to these Article 32 hearings and how a government can perfect its case. Because as we know, just very recently, perhaps a month and a half ago, under 2 months ago, we know that it's mandated now for every Article 32 hearing involving a sexual assault for a JAG to be the sitting investigating officer. And when we did this a long time ago, we didn't always have JAGs sitting as the investigating officer in the Article 32 hearing. It could be an infantryman, someone with the engineering corps, people who would be real panel members. Now we have JAGs who sit on the panel, who sit as the investigating officer, and we don't always know what their level of experience is with regards to courts-martial, but we do know that when you have a JAG sitting as the investigating officer, they are more capable and able to aid the government in perfecting its case at the Article 32 hearing, to prevent a sloppy prosecution from becoming even more sloppy, and to try to help those prosecutors fix the problems and iron out any issues or mistakes that could later arise at trial. So again, this goes back to the issues of where victim advocates want to get rid of Article 32 hearings, where Congress is now mandating a big change to get rid of Article 32 hearings. Mike, they're only hurting themselves, okay? They're only hurting themselves because these JAGs who sit as investigating officers can really help the prosecutors perfect its case. They're only hurting things, Mike.
Well, Ernesto, a lot of times whenever you make decisions based on emotion, which is a lot of this war on sexual assault, when it's motivated by a propaganda movie, the Invisible War, and a lot of decisions are based on that
I've
gut.
seen it, Mike.
It's a interesting. If you haven't seen it, I encourage everyone to go out and watch it. It was put together and pushed forward by victim advocates that are filing a lawsuit. And I've said this all along. This is about money. It's not really about victims' rights. It's about people wanting to win. Probably what they want to be the largest lawsuit that the military has ever seen, where they get, you know, 10,000, 5,000 alleged victims together and sue the government. And they've already tried to do that once. They failed, but they're not stopping, because imagine if they got a class action settlement for every alleged victim that's ever been in the military that's still alive. I mean, you're talking billions and billions of dollars,
Sure.
whether or not the person was actually a victim or not. So, I want to point something out. An attorney, I think her first name is Susan Burke. She was at the Naval Academy case, and she was representing the alleged victim, which is how it got that much publicity. She also was in the movie The Invisible War, and she's also a big advocate of the military, of the media's attacks, and she's behind a lot of those media attacks on the military, saying that they're not handling sexual assault right. What I think she's doing is trying to build up her case to get the public on her side, to get Congress on her side, so that she can one day win a large class action lawsuit and win a lot of money. I mean, if she wins a lawsuit for $50 billion, she's going to become a very wealthy person, and she has a history of being successful with these types of lawsuits. So make no doubt about it, all these people running around that are being manipulated by propaganda and the media and stories about 30 to 40-hour cross-examinations. I'm talking about the Naval Academy cross-examination. I don't even know if that's true, okay? But that's what's out there. That's the perception that's out there, and perception becomes reality. So when you're making decisions based on emotion, and here's the thing, if the military keeps switching and changing their military justice system, they're basically admitting that it was not adequate, which is setting her up for success in her future claims. Because if you go and make all these changes to a system to make it better, and you keep doing it over and over again, admitting you're wrong, admitting you didn't do your job, admitting you weren't hard enough, admitting that the military didn't investigate, you're basically conceding that the military was negligent in handling these cases, which is, in my mind, admitting liability. So don't forget what this is really all about. It's about money. On the fringe, you have a few radicals. And Ernesto, earlier today we talked about a taxpayer-funded symposium that's going on right now. Actually, a news story came out today. The U.S. Institute of Peace, a taxpayer-funded organization, had a conference this week, and they're complaining that the military, at this conference, one of the speakers was criticizing the United States for spending more money on counterterrorism than they do on sexual assault prevention. And I wanted to get your take on that, Ernesto, because we spend a lot of money on counterterrorism. I don't know if we're going to be spending a couple $100 billion on sexual assault prevention, but I wanted to get your opinion on that new development.
That is one of the most ridiculous things that I've heard, Mike. It really is, and it kind of goes to show how the media itself is perpetuating the problem. We have a lot, and this is what I mean. I almost believe that we have a lot of sex assault in the military because that's what we're told. We have problems in the military with sex assault because that's what we're told. And what that does is it's very harmful to the system itself. It's very harmful to investigations because regardless of the weight of the evidence, there could be no evidence, zero evidence, nothing more than baseless allegations from a very uncredible source or an uncredible alleged victim. And now you have an officer, an enlisted member whose life is in jeopardy because of these false allegations that are perpetuated by members of the military who know how to work the system and who understands what they have to gain by claiming sex assault and claiming to be a victim, Mike. And I think that's the big problem that we have right now is this perpetuation of fantasy. Um, I mean,
Well,
that is my initial take from that statement, Mike. It's just ridiculous to spend that much money on sex assault.
Well, I agree. I mean, it's sort of anytime you declare a war on something and you put hundreds of millions of dollars to try to stop the problem. Sometimes the problem is not as exaggerated as you would think, and especially when there's money to be made. The propaganda comes out, and then all of a sudden you get all these people that are hired. I'm talking about hundreds and hundreds of additional law enforcement, sexual assault prevention, and in some cases, I mean, it went from being approximately 1,000 worldwide of people involved in the victim advocacy program, victim witness program. Now there are thousands and thousands of. I've heard upwards of 8,000 people trained in sexual assault awareness, not just awareness, but in prevention and as victim witness liaisons, as the VWAPs and all that. And so what you have is you have all these people that are told there's rapists hiding behind every corner. There's rapists everywhere you look. Men are rapists. Men in the military are rapists. And like the symposium I was talking about, they blame the masculine culture of the military. That's what's causing all these rapes. And so when you're told over and over again that there's a very good chance you're going to be a victim, you're a female, you really can't consent if you have anything to drink, all these rapists are going to take advantage of you. By the way, all your past sexual encounters that involved any alcohol, you were probably taken advantage of and raped. Have you ever been in a situation where you feel guilty the next morning about the sexual activity that you had? You're probably raped. If you weren't raped, then you were taken advantage of. That's another crime, wrongful sexual contact. So if you ever have had any sexual contact with someone and you wish you didn't, then you're a victim. Come to us. We will give you money. We'll diagnose you with PTSD. That's what's going on, and I'm not exaggerating. I get asked this question all the time. Why would someone put themselves through this process? Well, it's in many of the cases, the person doesn't even come forward. It's one of these new trained people that are looking for victims and drumming. They're drumming these people up. I mean, I'll give you an example. A case I recently had. There was an airman that didn't do well on a test. She was in charge of loading gear on top of either C-130 or some aircraft. But my point is, she was emotional because she didn't do well on a test, so she fell, so she started crying. And anyway, her instructor immediately said, and this is a seasoned enlisted member of the United States Air Force, immediately thought, something's wrong. This reminds me of the sexual assault training that I just had, where someone's not on their game 100%, where someone's emotional. The fact is, she had cheated on her husband, and her husband had found out about it. She was very emotional about that, and she wasn't a top performer anyway. So the idea that anytime you see someone not having a good day or pouting around, it must be because they were raped, because there could be no other answer. And people were told that if you feel guilty the day after you have sex with someone and you cheat on your husband, then you probably didn't want to do it anyway. The person, that evil devil, probably just manipulated you, or he used rank on you, or maybe he quote plied you with alcohol. That's another thing we've been hearing a lot. 2 to 3 drinks is not plying someone with alcohol. But that's what these people are being told, and then they're being told you're not a victim. Don't say those words. You're a survivor, and then they're sucked into the system that turns out court-martials, and it's really it's an injustice for the people that think that they were sexually assaulted. Because if you weren't sexually assaulted, if you went out and had a couple drinks, started flirting with someone, cheated on your boyfriend, and the next day when you wake up, you're like, oh shoot, I shouldn't have done that. Well, you know what? That's a lesson to maybe not go out drinking with people that you might hook up with, to not cheat on your boyfriend, okay? Deal with it. It doesn't mean that you've been victimized by anyone. As a matter of fact, you're the one that should probably be held responsible for your poor decision making. And that brings up the final point, Ernesto, and the Air Force, once again, always trying to go that extra. I got to give them credit, because these guys are bending over backwards to try to stop sexual assault and to show that they're cracking down on sexual assault. No matter what they do, the politicians are coming after them. here's a real short story. They posted. You've probably seen these. These are in every military installation that I've ever been at. Signs about sexual assault prevention. And I'm going to ask for your comment on this in a second, Ernesto. But one of these signs that was in the bathroom gave some very simple steps on how to avoid being victimized. It was not just for women; it was also for men. Don't go out drinking with people you don't know. Don't drink excessively. Don't go home with a stranger. Don't accept open bottles of alcohol or alcoholic drinks from people you don't know. Don't walk down dark alleyways in the night without a friend. I mean, go out with a close buddy. Anyway, the media has twisted that, and now they're saying that the Air Force is perfect example of victim blaming. What are your thoughts on those efforts and on that sign in particular I was telling you about, Ernesto?
Mike, herein lies the problem. And these signs and the flack that has been generated because of these signs almost epitomizes what part of the problem is. And part of that problem is apparently the military does not believe females can be responsible for their own conduct. Apparently the military does not believe females or anyone can be responsible for their own conduct, that they're not smart enough, knowing when to drink and when not to drink, that they don't know who to hang out with and who not to hang out with. And therein lies the problem, Mike. We're creating, and the military is creating, this victim mentality that basically says, hey, you 20-year-old or 19-year-old female, you're not smart enough to make the decisions on your own. And that's completely false, Mike. That's completely false. And instead, these signs are great. These signs are telling young airmen, male and female, to be responsible for your conduct, who you hang out with, who you drink with, how much you have to drink. What is wrong with that? What is wrong with our military leaders telling young men and women in our military to be responsible? There is nothing wrong with that, but the media wants to portray the military as these barbaric rapists, and that's not true. And in order to portray the military as these barbaric rapists, the media and some of these victim advocates have to create an atmosphere where young men and women simply cannot make decisions on their own and are therefore victimized by everyone around them. That's my take on that, Mike.
Well, Ernesto, that brings us to a close on this episode. It was great to have you on here for the first time. We in the next couple episodes, we want to start. You're going to see Ernesto on here more frequently. Tim Balecki will be back shortly. You're going to see Tim, myself, and Ernesto doing three-way interviews, and we're also going to be bringing on some additional guests here in the coming months. So stay tuned. And for the Military Law News Network, I'm Michael Waddington with Ernesto Gapasin. Until next time.